Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
All right, we head now to your More Law Connection, where attorney Dan Moore is answering viewer emails. Good morning, Dan.
Morning, Deb. Merry Christmas.
Merry Christmas.
Merry Christmas, everybody out there in TV land. Our first question is from Nancy. Nancy asked, my mother is in a nursing home and has dementia. I am concerned about bruises I see on her when I visit, but I'm told it is nothing. How can I find out? Well, unfortunately, this is one of those concerns that arises frequently with nursing home patients. Now, nursing homes obviously don't want anything wrong to happen to the patients that are residing with them, but sometimes things happen. You have to determine in a situation where a relative has bruises, whether those bruises are caused by a normal bump, whether maybe the bruising is exacerbated by medication that the patient's on, or, of course, the worst is if the bruises are caused by some sort of physical trauma that's done by an individual working at the nursing home. You don't want those things to happen. You should know that the law provides certain rights for nursing home patients. They have a right to choose their doctor. They have a right to participate in the plan of care that the nursing home is constructing for them. They have a right to meet with nursing home personnel to discuss these things. So I would encourage you to go meet with your mother and the nursing home people and talk to them about this incident. Meet with the doctor. Ask the doctor, what are the bruises most likely caused from? If they're a suspicious cause, then you want to kind of work your way up that nursing home chain. Exercise those rights that the law gives you, because the more that you're involved with your mother's care and the more that your mother's tuned in to what's happening to her, the less likely that something bad is going to happen and she's going to need further care. Deb, back to you.
All right, thanks a lot, Dan. We'll see you again in a few minutes. Welcome back to our guest, Rick Schulte. Thanks for joining us.
Thank you. Glad to be here this morning.
We will go back to the phones right now. We were talking about product liability, and we have Tanya from Clarksville on the phone. Tanya, you have a question about some artificial mesh that's in your stomach. Is that right?
Yes, I had 2 hernia repairs, and the mesh has been recalled. And the first time I called, it said the mesh that I had was not recalled, and it would be eventually. I don't know where to go now.
So what does a person do in a situation like this?
Well, the first thing I have for Tanya is, Tanya, have you had a problem with the mesh, or are you just aware that it's been recalled?
I've continuously had problems.
Okay. All right. So, Rick, good question. This mesh business is highly controversial. She's talking about a mesh that was implanted in her stomach area. I know there's a lot of litigation over transvaginal mesh as well. Tell us about that.
Most of the claims related to the vaginal mesh relate to claims that deal with whether the mesh was improperly implanted, which potentially arises the question of whether it was a medical malpractice and the doctor appropriately used that mesh. But there's also a consolidated litigation in West Virginia, and people have been filing claims, thousands of them around the country, for vaginal mesh. Women who are suffering from incontinence and prolapse went to typically an OBGYN who implanted this mesh. One of the challenges or problems faced with this is that a urogynecologist is usually the expert with the appropriate training and expertise to do the types of surgeries that the mesh companies, as plaintiff attorneys will allege, had OBGYNs use the mesh, when in fact it should have been a urogynecologist that was doing the appropriate surgery on these women.
So what about the other kind of mesh, basically where they've used it in other parts of the body, like in Tanya's case in the abdominal area?
For Tanya, what I'd really like to find out is exactly what type of mesh she had. For example, there was a lot of litigation around the Kugel mesh, which is a hernia mesh that was used. And again, it goes back to product ID. She needs to get to an attorney who can determine what mesh she had implanted to find out not only if the government had recalled it or issued a warning, but if there was a problem with that mesh. Just because the government doesn't say there's a problem doesn't mean there is one.
Okay. All right, let's get back to the phone. We have Liz in Cincinnati. Go ahead, Liz.
Hello?
Hello.
Hey, Liz.
Go ahead.
Yes. Hi. I went to a doctor for ear infection specialist, and he gave me some medicine.
which caused me to actually, he didn't know the medicine caused, I went into the hospital, I had to rush to the hospital right away. It caused me that almost had one kidney failure. My kidney count went up so high, getting the potassium up over the level, and I was told to go to the hospital right away, and they had to get my potassium down right away and everything, and I could have dropped down dead from the medicine. My doctor, my primary physician, called the doctor that gave me the medicine, and the doctor said he didn't even know the medicine caused it. When he knew my history, which I wrote everything down, and before I even they give me medicine, I tell them about my history, so to make sure they don't mess me up with medicine. And he still gave me the medicine, which caused I just woke up one morning, my legs was killing me in the back, and I couldn't walk. So I called my primary physician. She told me to go get blood work done, and that's when they told me I was walking home from the get the blood work done. They called me, so I had to get to the hospital. My kidney hypertension doctor called me, so I had to get to the hospital right away.
Okay, Liz, I think I understand that there's... Liz, hang on just 1 second. Thank you. So, Don, I think you have enough information for, what I'm sure that this happens. People get medicine that they're not supposed to have at levels perhaps they're not supposed to have.
Well, that's exactly right. Liz, thanks so much for all the details that you've given us. And frankly, these are detailed cases. You have a combination of things sometimes, which Rick alluded to just a few minutes ago. Often you have a product liability claim, that is where a product is in this case, maybe a bad medicine. It causes too many people complications and difficulties that you wouldn't normally expect. That might be a product liability claim. Two, and often it's a med-mal claim, and that is where the doctor has not either paid attention to the patient or gotten sufficient history to make a determination as to whether this medication is appropriate, or has misprescribed it as far as amount or frequency, or has failed to monitor the patient thereafter for complications. Lots of details, very fact-driven situation. You've given us a lot of facts. The only way someone can really evaluate it is to go through it, get the medical records, and compare it to your situation and what other information is available as far as product recalls or things like that. So that's something you just have to look into more. One extra tidbit, the degree of damages. You had to go to the hospital. That indicates some substantial damage, but for products liability or med-mal, they're very expensive cases to bring. We normally are going to spend on one that's a standalone. We're going to talk about mass torts in a few minutes, but as a standalone case, we're going to spend $100,000 or more. So the damages have to be really, really heavy. That is a bad result for the patient. So best of luck, and thanks for calling.
Okay, let's go back to Dan Moore with another email question. Dan?
Okay, our second question this morning is from Tina. She says, I went to a company Christmas party where alcohol was being served. Some people seemed to have too much, but there weren't any provision for a ride home. Could the company be responsible for any accidents that may have caused or may have resulted from the party? This is Christmas time that we have the requisite Christmas question. The answer, though, really doesn't just apply to Christmas parties. It really applies to anybody who's not a liquor permit holder. So a liquor permit holder would be a bar, would be a store, places that sell alcohol for profit. If you are a person throwing a party at home, if you're an employer or a business throwing a Christmas party, you are considered a social host. Now, social hosts are dealt with differently depending on what state you're in. In Ohio, for example, social hosts are generally not liable for the acts of third parties. So if you go to a Christmas party and you get drunk and you go out and hurt somebody, the person or your employer who threw that Christmas party isn't responsible for what results, even though you got drunk at the Christmas party. That's just the law. There are some exceptions to that, however. If the business serves a minor, if the business serves alcohol during business hours, and then the employees go and work, and during the performance of their work, they injure somebody, business could be responsible in that circumstance too. But generally speaking, in Ohio, social host just not responsible for what happens. Okay, if you have a question and you would like us to take a look at it, go to the fox19.com website, click on the More Law link, and fill out the Send Us Your Question form, and submit it to us. We will answer your question as best we can. Merry Christmas to everybody, and we'll see you all after Christmas, right before the New Year trip's over. All
right, we'll see you again on New Year's Eve, Dan. We will be right back. Give us a call, 421-4691, talking about product liability. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show. So there you see our guest today, Rick Schulte. You can find him in Vandalia, Ohio, or at LegalDayton.com. And as every week, Don Moore and Dan Moore on Nimitz 2 Drive, the Moore Law Firm. All right, and we only have a few minutes left, and you wanted to be sure to show the viewers a picture and give some information.
Yeah, exactly. We had a case, Dan and I do products cases as well, and we had a case where a fellow seatbelt failed several years ago, and those are really expensive cases. This was a case where the guy would not have been hurt at all had his seatbelt not failed, but instead he was thrown out, suffered lots of very serious permanent injuries, and we had a great deal of difficulty proving that basically the seatbelt wasn't supposed to break during a moderate crash, and that's what happened. So what we're, I guess the point or the takeaway from this is that when you buy a seatbelt or a safety device in your car, it's like buying a football helmet. It's only used for one thing. It's only for crashes. And people oftentimes don't think about themselves of buying a safety device for a crash, but that's exactly what it's for. So if something like that fails, you may have a case if injury results.
Okay. We really want to get to this last caller. Dennis in Cincinnati. Dennis, I'm sorry. I understand that your wife passed away after using Ativan.
Yes.
And you've been offered a settlement?
Yes.
And then tell me your question after that.
Does it cost to get a second opinion?
So you want to talk to a second lawyer about whether to settle?
That's a great question, Dennis. I'm sorry about the loss of your wife. Rick, what do you got for him?
It's a very good idea to get a second opinion, and frankly, most attorneys that are handling these types of cases will do that for free because they work on a contingency fee basis. I would encourage you to trust your attorney, listen to his advice very carefully. We're not wanting to second guess him, but it's a good idea to get a second opinion.
And typically, whether it's a med mal or a products case, it's a contingency fee, and what's the contingency fee generally for either one of those?
Well, the contingency fee in those types of cases is usually 40%.
They're expensive. You talked about they're very expensive to
very time consuming, very expensive, very risky. The attorneys that know what they're doing in that area almost always charge 40%.
Rick, thanks a lot for being here.
Yeah, it's a pleasure. Thank you.
I know that you're going to do your Christmas shopping after you leave. Good luck with that.
I hope I can make it.
Yeah, I hope your wife's not listening.
We'll see.
All right. Thanks. I guess we'll see you on New Year's Eve.
We will indeed. We're going to talk about DUI on New Year's Eve. Imagine that.
I think that is very appropriate. We'll try to help some people out.
All right.
All right. We'll see you all back here next Monday morning at 9:30. Again, taking your calls about DUI. In the meantime, enjoy the holiday. Have a good
Christmas to everybody.
Merry Christmas.
Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Good morning. You know, people who get behind the wheel after drinking can wind up facing serious consequences. Will a DUI mean a fine, losing your license, or jail time? More sobering is the possibility of injuring or even killing someone while driving drunk. What recourse do victims have against drunk drivers? If you have a question about a DUI-related arrest or injury, give us a call, and we, of course, will take your questions live. With me, as always, Don Moore. How are you this morning?
I'm doing great. How you doing,
New Year's
Deb?
Eve morning, very good.
A good Christmas, I hope.
It was wonderful.
And I guess for tonight, party hardy, right?
I'm going to party hardy at my house. I think we're going to have some people over, and that'll be nice.
All right, that sounds pretty safe. You know, one of the things I'm excited about today's topic because it's something that so many people really just don't know much about. Everybody thinks with the DUI law that it's illegal to drink and then drive, and that's just not the case. And we've got an expert here to help us. Nick, thanks a lot for coming.
Thanks for having me.
You know, Nick, let's start off with, if somebody gets pulled over and they believe they're getting pulled over for a DUI-related offense, what should they know? What should they do or not do?
First of all, remain calm. Remain calm. It's not the end of the world. Second thing, be polite with the officer. getting to the most important part of it is do not do the field sobriety test. Do not blow in the breathalyzer when asked.
Well, it's really hard to do that. If the police officer is saying to me, here's how this is going to work. I need you to walk this line or touch your nose or whatever that is, and this is how, and you have to blow into this device. I mean, how do you say no?
Because it's your right to say no. Remember, they're trying to collect evidence against you. You just don't want to hand them evidence. So it is your right to say no. You can refuse the field sobriety test without any penalty. However, if you refuse the breathalyzer, there is an automatic driver's license suspension that comes along with that. But generally, there is no incentive to take that breath test.
Okay. Don, you wanted to add something to that?
Well, yeah. I didn't really give Nick the proper introduction that we normally do. Nick Klingensmith is a lawyer that handles DUIs. Nick is an elder grad. Nick is a former city prosecutor. He went to school, University of Cincinnati, got his undergrad degree, and then he also went to Chase College of Law. So he is a Cincinnati boy through and through, and he knows his DUI stuff. He's prosecuted tons of these cases.
Well, then we are glad to have you with us.
Thanks for having me.
Thanks.
I do appreciate it.
So, Nick, what you just said a minute ago, it sounds real easy. The nice police officer says, I want you to step out of the car. First of all, do you have to step out?
You do.
Okay,
You do.
and if he asks you for your license, do you have to give him a license?
You do.
And then he says, he doesn't ask you if you've been drinking, he asks how many you've had to drink, right?
That's correct.
And they've heard probably 2 beers before.
That's the usual line.
Yeah, and 2 means somewhere between something and 200, but it always means that you've admitted drinking.
That's correct.
And so that's a bad thing.
It is. It is.
And so then he says, we want you to do some field sobriety tests like touching your nose and walking the line and reciting alphabet backwards and following his pin around and all that stuff. And what do you say to that?
No.
Okay, tell us more.
Basically, you do not have to do those tests. You're really just handing them evidence to use in your prosecution. A lot of times officers have already made their mind up that you've been drinking, and you're probably going to be arrested regardless of how you perform those tests. The only time I'd ever tell someone to take those field sobriety tests if they've absolutely not been drinking, because they cannot benefit you.
So drinking or not, don't do the psychomotor test.
That's correct.
All right, great.
Okay. Let's head to the phones now. I think first up we have Doug in Williamstown. Good morning, Doug.
Morning.
How can we help?
Yes, because of my age and my previous injuries, I cannot pass a field sobriety test. Coordination and everything's not right, but they're going to think I'm drunk and lock me up anyway.
So Doug, let me just mention something to you. No one can pass them. Unless you've been practicing touching the very tip of your nose with your index finger while you're looking up at the sky with your eyes closed and your heels put together, you're simply not going to pass that test. It just doesn't happen. So don't do them ever. I think that's what Nick just said. And coordination or no coordination is just it's not going to work.
But what he was saying is he's concerned that somebody's just going to lock him up under the, they're going to assume he was drinking because he refuses to take them. But that's not necessarily true.
The officer should be asking you whether you have medical conditions before performing those tests, and by all means you want to explain to them all the medical conditions you have, so they do not believe that you were drinking.
Okay. Let's go back to the phones. Let's go to Bob in Coleraine. Bob?
Yes. Hi.
Hi.
My question is, I had a DUI in 89 and 90, and I was wondering how you go about getting that off your record now that I'm way older.
That's a good question.
Is it possible to do that?
It is not possible under the current law to have an OVI or DUI. They're now called OVIs expunged. It's just not possible.
Given the length of time that has passed since then, would he, do they say, oh, okay, he had one 20 years ago if he would get pulled over again, or does that still count against you?
It does. There's actually 2 look-back periods when it comes to an OVI or DUI, 6 years and 20 years. DUIs that you have in the last 20 years count against you if you decide to refuse a breath test.
So basically, a DUI is a really serious charge.
It is. It sticks with you for life.
And would you tell us just what the penalties are, like what the law provides as far as a DUI goes?
If it's your first DUI ever, first in 6 years, it's one of the look-back periods. Basically, you're looking at a minimum mandatory 3 days in jail or in a driver's intervention program, if you've heard of the hotel class.
Okay.
You're looking at fines from anywhere from $375 up to $1,075. You're looking at 6-month driver's license suspension up to 3 years. You're looking at expensive reinstatement fees. You're looking at court costs. You're looking at probation, and not to mention all the collateral consequences that come with the DUI conviction, maybe loss of job, increased insurance rates. There's just a whole host of problems that come with that conviction.
Okay, so Nick, you mentioned driver's intervention class. That's not free, is it?
No, no.
What's that cost?
Depending on what kind of room you would like at the hotel, they range anywhere from $400 to $700, depending on the hotel that it's at as well.
So when you say hotel, do you mean hotel literally?
It is actually at a hotel now. One of the programs, Access Ohio, does take place at a hotel.
Is it a flea bag or is it a decent place?
I don't know. I've never been there, so.
We're getting down to the nitty-gritty.
I'll bet you've had some clients who have.
I have. Let's just say it probably wouldn't be their first choice of hotels to stay at.
All right, so I want to get this straight. We got about $400 to $700 for the driver intervention program. You got about $375 minimum.
Minimum.
Fine. Okay. And you got court costs. What's that?
I think they are $104 right now.
$104 court costs. Okay. And then you mentioned reinstatement fee. How much is that?
Generally $475, but there is some wiggle room with that, and depending on what the actual conviction.
Okay. And I can tell you from a more civil standpoint, your insurance is going up, and if they don't cancel you, it's going to cost you somewhere between $500 and $1,500 per year extra for minimum 3 years. That's a lot of jack. That's an expensive ticket.
It is.
All right. Well, we are going to take a break right now. We'll be back taking your questions about DUI. Give us a call, 513-421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
We're back talking about DUI today on More Law, but before we take another call, we'll go to Dan Moore in the More Law Connection answering viewer emails. Dan?
Hey Deb, how you doing?
Very good. Yourself?
Pretty good. Happy New Year to you.
To you, thank you.
Today our first question is from Edna. She wants to know, I went to the ER last week for a broken ankle and got a staph infection. Can I sue the hospital for making me sick? Okay, there are really, whenever you enter to a medical institution, whether it be a hospital, a nursing home, an urgent care, you have a chance of acquiring an infection. And legally speaking, I think there are two causes for an infection to occur. One is because somebody did something wrong. They failed to sanitize an instrument. They failed to wash their hands. That's negligent, and that could cause an infection. But by far, the most common cause of an infection is it's just a risk of the procedure. It's a risk of going into the hospital, into that nursing home. There's lots of diseases floating around there. You can pick something up while you're there. It's just a risk. And if that's the case, and the doctor tending to your ankle did everything he or she was supposed to do to protect against an infection, and the infection still occurs, you don't have a case, rather. If, on the other hand, you're able to prove that the doctor didn't wash his hands or use something that was dirty, or the hospital did something that didn't protect against an infection, then you might have a case. But again, by far the vast majority of time, it's just a risk of being in one of those institutions. Deb?
All right, Dan, thanks a lot. We are back again with Nick Klingensmith, our guest. Thank you for being here.
Thanks again.
People are looking for a lot of information today. We are talking about DUI. Let's head back to the phones. First up, Cliff in Milford. Cliff, I understand you have a question about blood test versus breath test.
Yes, ma'am.
Please, can you go ahead? I'm not sure exactly whether to take one or the other. What are you asking us?
Well, my question is, if you refuse the breath test and they take you to jail, will they administer a blood test, or is it legal for them to do so?
We were just talking about that during the commercial break. Can they do that?
Generally, what happens when you refuse a breath test, besides some exceptions, there are exceptions to every law, is that'll be the end of it. They're going to probably let you call someone to come pick you up from the police station. Very rarely does anyone actually go to jail the same night after being arrested for a DUI. So once you say no to the breath test, that's pretty much the end of it.
But then how would they end up charging you with a DUI?
Well, there's different ways they can charge a DUI, but at that point, the police officer already believes that you've been operating a vehicle while under the influence, and he's going to go ahead and write you that ticket and charge you with the OVI.
Okay.
So whether you get convicted of the DUI or not, you still got consequences for refusing the breath test, right?
That is correct.
And what are they?
If you refuse the breath test, you're going to lose your license automatically for a year, and also you cannot get privileges for the first 30 days of that suspension.
Okay, and when you say privileges, just so it's clear, what does that mean?
To and from work, to be able to get back and forth. If you're in school, to get back and forth from school. And then there's some other privileges that judges may grant.
Okay, so it's clear, if you refuse a breath test, whether you're convicted of DUI later or not, you're automatically going to lose your license totally for 30 days minimum, and for a year as far as pleasure driving for sure.
That's correct, but there are exceptions to that and ways around it.
And that's where getting a lawyer that knows the ways around it comes in.
Definitely.
All right.
Okay. Let's head to Carl in Lebanon. Carl, you had a question about refusing a breath test, right?
Yes.
Go ahead. I'm sorry, I didn't understand the whole question.
Okay, well, I heard that there's a law out that they can physically charge you with a crime for refusing any field sobriety and or breathalyzer.
Well, that's two separate things. There is no penalty for refusing to do the field sobriety test. You're free to say no to those. However, if you refuse to take the breath test, we were talking earlier about the look-back period. If you have a prior DUI conviction the last 20 years and you refuse the breath test, it is actually a separate charge. Again, the law is written very confusing, and there's a lot to it and a lot of different ins and outs. But yes, there is a separate charge for refusing a breath test if you have a prior conviction for DUI.
But there's never a charge for refusing to take the finger to nose or the walking or all those other tests. You don't have to do them at all.
That's correct.
And there is a difference between taking a breath test on the scene, the little portable thing they carry around with them, versus back at the station. Is that right?
That's also correct. If they ask you to blow into the portable breath test roadside, as we call it, or at the scene or on the street, there is no consequence for refusing to take that test. In fact, most courts will not even take the result of that test into evidence.
Okay. All right, let's head back to Dan now with another email question. Dan?
All right, thanks, Deb. Our next question is from Roy. He says, my son is graduating from high school in the spring. Do I still owe child support when he goes to college? The answer to this is actually pretty clear in the law. There are really two ways that set the time period within which you have to pay child support. If you have an agreement and you agree to pay child support, for example, in perhaps a divorce settlement, you agree to pay up until the kid gets out of college, or you agree to pay until the kid gets 20 years old, or whatever the agreement is, that would govern. Now, the law, if you don't have an agreement, the law sets a time period, and that's 18 years old or until the kid graduates. Now, if the kid takes an extra long time to graduate, and he doesn't graduate until he's after the age of 19 or he's 20 or something like that, then it cuts off at 19. So you have an agreement or you have the law, and whichever your situation dictates will govern there. Okay, if you have a question, go to the fox19.com website, click on the More Law button at the top of the page, fill out the send us your question form, and of course send it in, and we'll do our best to answer as always. That is all I have for today. Deb, have a happy new year, and don't get in any trouble tonight.
Oh, I'll do my best. Thank you for looking out for me, Dan. It doesn't sound like any fun, though. But we will be right back here on More Law talking about DUI. Give us a call, 513-421-4691. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so there you go on your air right now. Nick Klingensmith, you can find him at klingensmithlaw.com. Don Moore and Dan Moore at the Moore Law Firm, morelaw.com. All of that information, though, fox19.com, and click on More Law. Today, of course, we are talking about DUI, and there's some really important information that you felt the viewers should have.
Yeah, actually a couple of things. And one of the things that I would encourage them to do is to take a look at Fox 19 and go to the More Law website, because two things. Number one, if you've missed a show that you're interested in, you can go back and see it. Two, we're going to show you a graphic in just a moment here. And basically, this is to help you understand how many drinks it takes to get you over the legal limit. And one of the things that was terribly disappointing to me recently I was doing depositions in a case that is taking under oath, questioning bartenders about what they knew and how they were trained and how they were taught. None of them were familiar with this graphic that we've got in front of you right now, and you can go on our website and we'll have a link to that. And basically what it says is you're going to get about 0.02 per 12-ounce beer or 1 ounce drink of alcohol. In other words, if it's a mixed drink, 1 shot, you're going to get about 0.02 for the average person. Varies depending on your body weight, varies depending on male or female, but 0.02 per drink per hour. So basically to get to 0.08, you got to drink 4 drinks inside of an hour. It accumulates though. You lose some, you'll lose 0.02 generally about per hour, but it'll continue to accumulate as long as you're greater than that. That's a big deal, and a lot of bartenders don't know it. In our case, we had a person that was intoxicated well above, more than double the legal limit. They went out and they were killed in a fatal accident. They killed themselves, and unfortunately they hit my client, who was an innocent, and permanently disabled them. So it's a big, big deal. And for a bartender not to know, and the average person not to know, there's no law against drinking and then driving. There's a big law, a big important law against driving while impaired or being above the legal limit. So if you don't have any idea what it takes to get you to the legal limit, how are you supposed to know?
Right. And you know, we have a caller who has a question that's very similar on more of a personal level than a professional bartender. But Judy and Trenton, you had a question about the consequences for you as a party host, right? If your guests have had too much to drink?
Exactly. As a bartender, I was just really concerned with what could happen to me if somebody does get out there and something happens to them and I am the one that served them.
Mm-hmm.
Well, and basically you can be on the dime. And there are the dram shop law is the one that applies to professional bartenders. And basically in the dram shop law, what it says is that if you negligently allow a person to become intoxicated and they're hurt or they hurt someone else on the premises, that the establishment and the bartender that served them can be liable. It gets a little trickier if they're off the premises. That would be like they leave the parking lot, and like the accident I talked about where we had a client permanently disabled as a result of a drunk driver. In that case, the bartender has to have served a person who was noticeably intoxicated. And so that means that their actions, all the things we talk about, slurring, staggering, change in the rapidity of their speech, their voice volume, loss of inhibitions, they're singing, they're whooping it up, all signs that as a professional bartender you probably recognize. The sad thing is, at least when I was taking the depositions of these bartenders, most of them hadn't been trained. Some of them had no training, some of them had a little bit of training. None of them were familiar with the blood alcohol table that we just showed on the air a few minutes ago. So that's really sad. But you can be liable as the actual bartender doing the serving, as can the institution that serves you under that dram shop law I just discussed.
But Don, what about a homeowner? You know, there will be a lot of people tonight having New Year's Eve parties at their homes, yep. And people will be there and they will be drinking, and then they will be leaving. Who's responsible if something happens?
Well, that's a really good question, and for a social host, it's pretty clear in the state of Ohio. The social host has no responsibility for an adult that they serve, period. The drinker, the person who actually drank the drinks, they're the only one that's responsible. 2, if you serve minors as a social host, now you're on the dime. If you serve kids, 16, 17-year-olds, stuff like that, and they go out and hurt somebody, not only is the kid responsible in their insurance, but also the person who gave them the booze.
Okay, great. And we just had about a minute left, Nick, but you wanted to be clear to folks that there's really, on a night like this, they do have some recourse. I mean, certainly we can all leave a car in a parking lot and get a cab, but there's some extra help out there for folks tonight.
Actually, tonight, and I believe tomorrow, there are free cab rides through AAA, and I believe also MAD, the MAD organization. But if you call, I don't have the number off the top of my head, but if you look online, there's actually free cab rides tonight. So tonight of all nights, there's absolutely no excuse to drive while intoxicated.
Okay. Thanks so much for joining us today.
Yeah, thanks a lot, Nick. Great to have you.
Thank you very, very much.
You have a good week yourself.
And you as well. I understand next week we're doing how to purchase car insurance.
Well, we'll be looking forward to that. It'll be how to purchase car insurance, then all about injuries the following week, divorce and child custody the week after that. Meantime, have a great week, and we'll see you Monday morning at 9:30.